The principle that government actions, particularly criminal investigations funded by taxpayers, should be transparent underpins a compelling argument for making all evidence collected by agencies like the Federal Bureau of Investigation, FBI, accessible to the public in some form, even in sensitive cases such as that of Jeffrey Epstein. While concerns about victim privacy, legal restrictions, and potential misuse of evidence often lead to sealing, the public's right to know, the need for accountability, and the societal value of transparency outweigh these objections. This article argues that all evidence from government investigations should be made available through structured mechanisms that balance transparency with privacy and safety, using the Epstein case as a key example. The imperative for transparency. Investigations conducted by public agencies are financed by taxpayer dollars and executed by officials accountable to the electorate, creating a democratic expectation of access to their outcomes. The Jeffrey Epstein case, involving allegations of sex trafficking and connections to prominent figures, underscores this demand. Following Epstein's death by suicide in August 2019, the FBI and Department of Justice (DOJ) collected extensive evidence, including documents, flight logs, and digital media. Partial releases, such as 200 pages in February 2025, included redacted flight logs and an evidence list, but thousands of pages and videos remain sealed, citing victim privacy and the graphic nature of materials, as noted by Attorney General Pam Bondi. This limited disclosure has fueled public distrust, with many alleging cover-ups to protect influential individuals. Transparency serves critical functions. It ensures accountability, preventing agencies from concealing misconduct or shielding powerful figures. In the Epstein case, the absence of a confirmed client list, as clarified in a July 2025 DOJ memo, could be better addressed through broader disclosure to dispel misinformation. Access to evidence also supports historical and societal understanding, enabling researchers and journalists to analyze systemic issues, as seen in partially released Epstein documents that clarified his network's scope. Finally, transparency reinforces democratic principles, affirming that government actions serve the public interest. Addressing privacy and safety concerns. Opponents of universal access argue that releasing evidence risks harming victims, witnesses, or innocent parties, particularly in cases involving graphic or illegal content. In Epstein's case, protecting over 1,000 victims, many minors, is a priority under laws like the Crime Victims' Rights Act, 18 U.S.C. Section 3771. Graphic materials, potentially including child abuse, are restricted under 18 U.S.C. Section 2252 to prevent exploitation. However, these concerns can be mitigated through structured access mechanisms. Number 1. Redacted releases. Documents can be released with sensitive information, such as victim identities, obscured. The DOJ's 2024 and 2025 Epstein releases demonstrate this approach, though broader disclosure could enhance public understanding. Number 2. Controlled viewing facilities. Sensitive evidence like videos could be accessible in secure government settings, preventing copying or redistribution, similar to protocols for classified records. Number 3. Time-delayed declassification. Releasing evidence after a set period, 25 years, balances immediate privacy concerns with long-term transparency, applicable to all cases. Number 4. Independent oversight. Neutral panels could review sealed evidence to determine public interest value, ensuring impartial decisions as suggested by legal scholars. These methods address privacy and safety while upholding transparency, allowing public access without compromising legal or ethical standards. Legal framework and reform. The Freedom of Information Act, FOIA, 5 U.S.C. Section 552, permits public requests for federal records but includes exemptions for privacy, law enforcement, and classified information, limiting access in cases like Epstein's. No federal law mandates automatic release of all evidence post-case closure, leaving decisions to courts or agencies. Legislative reform could establish a presumption of disclosure, requiring agencies to justify sealing, thus prioritizing public access. The Epstein case, where nearly 3,000 pages have been released through FOIA and lawsuits, shows partial transparency is feasible but insufficient to satisfy public demand. Concerns about public unrest or misinformation from unrestricted access are valid but overstated. Withholding evidence, as in Epstein's case, where a missing minute in suicide footage fueled conspiracy theories, often exacerbates distrust. Controlled, contextualized releases could mitigate false narratives, as seen in Virginia Giuffre's lawsuit against Ghislaine Maxwell, which unsealed significant documents. Broader implications. Universal access to evidence would enhance accountability across all investigations, exposing systemic issues like law enforcement bias or abuse of power. In high-profile cases like Epstein's, full disclosure could clarify allegations of elite involvement, reducing speculation. Structured access ensures that taxpayer-funded investigations serve the public, not select interests, and prevents selective disclosure as criticized by Bondi in 2025 regarding FBI withholdings. Conclusion. All evidence from government investigations should be accessible to the public in some form, as transparency is essential for democratic accountability and societal benefit. While privacy and safety concerns, as in the Epstein case, necessitate protections, redacted releases, secure viewing, delayed declassification, and oversight panels can balance these interests. Legislative reform is needed to prioritize public access, ensuring that evidence serves the citizens who fund its collection.